What we are witnessing in Florida is a despicable display of governmental petulance following a fundamental affirmation of our rights. For far too long, since 1987 to be exact, the state maintained an unconstitutional ban on the open carry of firearms, treating law-abiding adult citizens like criminals simply for carrying property in plain sight. Now, after the First District Court of Appeal correctly exposed this prohibition as inconsistent with the nation's historical tradition of firearms regulation, certain elected officials sworn to uphold the United States and Florida constitutions are openly refusing to comply. They are manufacturing confusion, spreading mixed signals, and actively risking the liberty of responsible gun owners by suggesting they will continue to enforce a statute a competent appellate court and the state's attorney general declared dead. This is not caution, this is political obstruction that creates a chaotic legal environment. The judicial mandate, dismantling the decades-old open carry ban. The seismic shift in Florida's regulatory framework began on September 10, 2025, with the decisive ruling in McDaniels v. State of Florida by the First District Court of Appeal. This three-judge appellate panel delivered a much-needed defense of the Second Amendment, explicitly overturning the state's long-standing open carry ban that had been on the books for decades. The heart of the court's reasoning was its application of the U.S. Supreme Court's 2022 landmark decision in New York State Rifle and Pistol Association v. Bruin, which established that firearm restrictions must align with the nation's historical tradition of firearms regulation. The Florida court correctly determined that the state failed to meet this high historical standard, emphasizing that the state government simply cannot altogether extinguish the right of law-abiding adult citizens to publicly carry arms, which inherently includes carrying them openly. This judicial validation meant that the portion of the Florida statutes, Section 790.053, criminalizing the open display of a firearm or electric device, was declared unconstitutional.
The immediate impact of the McDaniels ruling was magnified by the rapid response from the state's legal leadership. Just 5 days later, on September 15, 2025, Attorney General James Youthmayer issued a crucial guidance memorandum that dramatically affirmed the decision's reach. The Attorney General unambiguously stated that open carry is now lawful and should be considered the law of the state, instructing law enforcement and prosecutors statewide not to arrest or try citizens for simply carrying a visible firearm. This instruction was designed to bring immediate consistency to police conduct across all Florida trial courts, despite the initial ruling originating from just one appellate district. Prior to this court action, the concept of openly carrying a firearm in Florida was generally forbidden, characterized as a second-degree misdemeanor punishable by a $500 fine or up to 60 days in jail. Exceptions existed only for specific, narrowly defined actions, such as when a person was actively hunting, fishing, or camping, or if the firearm was briefly and openly displayed and the display was not in an angry or threatening manner. The new landscape, effective September 25, 2025, 15 days after the appellate opinion, means that open carry is now officially permitted for any eligible adult who can lawfully possess a firearm, eliminating the previous penalties for visibility. This judicial victory has forced an immediate fundamental reconsideration of enforcement priorities across all local agencies in the state. The conflict, jurisdictional disputes, and defiant enforcement. Despite the Attorney General's clear guidance proclaiming open carry the law of the state, the legal reality remains fractured and fraught with uncertainty, primarily due to Florida's hierarchical court system and localized resistance. The core of this fragmentation is rooted in the fact that the McDaniels ruling, while sweeping in its effect, was issued only by the First District Court of Appeal. While the Attorney General argues this ruling is binding on all Florida trial courts, the decision technically conflicts with the Florida Supreme Court's ruling in 2017, Norman v. State, which previously upheld the constitutionality of the open carry ban. This direct conflict means that the McDaniels decision will inevitably reach the Florida Supreme Court for mandatory review because it invalidated a state statute, leaving the ultimate legal status of open carry unsettled for the foreseeable future. The resulting confusion has been exacerbated by the public defiance of some elected constitutional officers, namely certain county sheriffs. These law enforcement leaders, often operating outside the First District's jurisdiction, have announced their intention to continue enforcing the previous ban. Their stated rationale rests on the claim that because the old law, Section 790.053, remains technically written in the statutes, they risk facing accusations of dereliction of duty, internal audits, or lawsuits based on selective enforcement if they cease arrests. This argument is profoundly flawed, however, as their primary duty is to Florida and United States Constitution.
By choosing to enforce an outdated statute that has been declared unconstitutional by a competent court and affirmed by the state's top legal officer, these agencies are actively infringing upon a fundamental right. The irony is that the sheriffs believe they are mitigating risk, but they are in fact opening themselves up to potential civil lawsuits down the road from individuals unlawfully detained or charged for exercising their rights to open carry. This institutional resistance generates perilous mixed signals and a legal mess for gun owners, who are left uncertain of their rights as they move between different judicial districts. Until the Florida Supreme Court provides definitive clarity or the legislature officially removes the unconstitutional ban from the state statutes, citizens are essentially forced to navigate a legal patchwork where rights are contingent upon local police preference rather than constitutional law. Non-negotiables, sensitive places, and prohibited conduct. The constitutional right to openly carry firearms in Florida, newly recognized through the McDaniels decision, is not absolute or immune from reasonable regulation. This is a critical point that responsible gun owners must understand. The ruling did not eliminate all firearm restrictions. Rather, it invalidated only the wholesale ban on visible carry in public spaces. Consequently, an expansive list of state and federal restrictions concerning firearm possession in specified sensitive locations remains fully operative. The core framework defining these gun-free zones is found primarily in the Concealed Carry Statute, Section 790.0612A, which dictates where both concealed and open carry remain prohibited. This list is comprehensive and encompasses essential governmental, judicial, educational, and public safety sites. For example, the law strictly prohibits carrying firearms into any police, sheriff, or highway patrol station, any detention facility, prison, or jail, and any courthouse. Crucially, even the parking areas surrounding courthouses may be prohibited. Furthermore, the restrictions extend to all legislative and democratic venues, including polling places and any meeting of the legislature or a committee thereof. Educational institutions are similarly restricted, making it illegal to carry in any elementary or secondary school facility or administration building, any career center, and most college or university facilities. The single narrow exception for a university setting is for a registered student, employee, or faculty member possessing only a stun gun or non-lethal electric weapon. Transportation and public gathering sites also feature prominently on the prohibited list, banning carry inside the passenger terminal and sterile area of any airport. A significant caveat applies to establishments serving alcohol. Firearms are strictly banned in any portion of an establishment licensed to dispense alcoholic beverages for consumption that is primarily devoted to such purpose. This nuance means gun owners must be particularly aware in mixed dining bar environments.
Moreover, the Attorney General emphasized that the constitutional right to carry is not a license for intimidation. Law enforcement retains full authority to prosecute individuals who exhibit firearms in a rude, careless, angry, or threatening manner, codified under Section 790.10 Florida statutes. Ultimately, gun rights proponents recognize that while they oppose the current restrictive list, any future statutory limitations on carry in specific locations must satisfy the historical precedent test established by the courts, meaning lawmakers face a high burden to justify restricting sites like schools and polling precincts by demonstrating that similar bans existed historically at the time of the Second Amendment's ratification. Preserving control, private property rights, and employer policies. One immutable fact remains entirely unchanged by the landmark open carry ruling, the deeply rooted right of private property owners to control what happens on their land. The McDaniels decision applies only to public property. This distinction grants private employers and businesses the absolute authority to restrict or outright ban the possession or display of all firearms on their premises, whether carried openly or concealed. The refusal by an armed individual to comply with a private property owner's warning to leave carries severe legal consequences. The moment a person carrying a firearm violates that instruction, they're committing armed trespass, which is specifically defined in Florida law as a third-degree felony. This penalty provides a powerful enforcement mechanism for retailers and businesses wishing to maintain a zero-tolerance weapons policy. To effectively enforce this, legal guidance urges private employers to proactively post clear, conspicuous signage at every public entrance stating "No firearms allowed." The corporate response to the new open carry reality has been varied, highlighting the power of private policy. Publix, Florida's largest grocery chain, made headlines by publicly affirming that it would align its policy with the new state law, allowing customers to open carry in its 882 Florida stores as of September 25, 2025. Conversely, many major retailers, though often permitting lawful concealed carry, continue to prohibit the open display of weapons. Companies like Walmart allow concealed carry but ban open carry, and others like Costco, Sam's Club, Sprouts, and Whole Foods maintain a long-standing prohibition on all firearms inside their warehouses or stores, regardless of the new legal landscape. This means that the practical exercise of the open carry right is heavily dependent on the policies of the specific business a person enters. Furthermore, for private employers, the ability to restrict firearms in the actual workplace is constrained only by one major law, the Bring Your Guns to Work statute, Section 790.251. This law ensures that an employer cannot prohibit an employee or invitee from storing a legally owned firearm that is lawfully possessed and locked inside a private motor vehicle in a company parking lot. Employers are explicitly barred from inquiring about a firearm's presence in a locked vehicle, searching the vehicle for weapons, or using a prospective employee's concealed weapons permit status as a condition for employment. Therefore, companies must diligently review existing weapons policies to ensure they do not violate this crucial parking lot protection while still exercising their right to enforce a complete ban inside their facilities.
Permitless carry, transportation, and red flags. The validation of open carry by the First District Court of Appeal must be viewed not as an isolated victory, but as the newest layer upon a foundation of existing pro-gun legislation already active in Florida. Most significantly, the state had already shifted into its constitutional carry era, allowing permitless concealed carry for qualifying individuals 21 and older since July 1, 2023. This major statutory change, enacted through HB 543, dramatically streamlined the ability of responsible citizens to carry a firearm without the mandatory state licensing process, provided they meet all other eligibility requirements. However, even with the new open carry rule and the prior permitless concealed carry law, obtaining a concealed weapon license, CWL, still provides concrete legal benefits. Foremost among these advantages is the ability to bypass the mandatory 3-day waiting period required for all firearm purchases from licensed dealers. This waiting period, excluding weekends and legal holidays, can be extended by individual counties up to 5 days. The CWL is also vital for residents traveling outside Florida, as it facilitates reciprocity agreements with the 37 other states that recognize the Florida license. The regulations governing firearms in motor vehicles remain highly specific and strictly enforced, irrespective of the new open carry ruling. For those transporting a handgun without a CWL, the firearm must be either securely encased or rendered not readily accessible for immediate use. The law defines securely encased with precision, including storage in a glove compartment, locked or unlocked, a zipped-up bag, or a snapped holster. Crucially, the firearm cannot be stored in a quick-access location like simply under the seat.
Long guns, unlike handguns, are subject to less rigorous rules and may be transported anywhere within a private vehicle for a lawful purpose. It is also imperative to understand that this expansion of carry rights does nothing to alter existing criminal restrictions on possession or the state's existing mechanism for temporary confiscation. The right to open carry only applies to those legally allowed to possess a firearm. This means that strict prohibitions remain in place for convicted felons, individuals with domestic violence restraining orders, and those deemed mentally defective. Furthermore, Florida's red flag law, risk protection order, which permits law enforcement to obtain judicial approval to temporarily confiscate firearms for up to a year from an individual deemed a danger to themselves or others, is entirely unaffected and remains a legal mechanism used by the state. This collection of laws creates a comprehensive structure, demonstrating that while the right to public carry has been affirmed, the state still maintains regulatory control over possession and dangerous conduct. The judicial striking down of Florida's 1987 open carry ban marked a resounding victory for the Second Amendment, firmly establishing the right of law-abiding adult citizens to openly carry in most public places. However, this constitutional clarity has been met with immediate political friction, resulting in a confusing patchwork of enforcement due to the clash between the appellate ruling, the Florida Supreme Court's prior position, and the recalcitrance of local sheriffs. Citizens must remain vigilant, understanding that while open carry is legal, sensitive locations and all private property remain subject to strict prohibitions, potentially resulting in an armed trespassing third-degree felony. The time for the Florida legislature to intervene and bring the statutes into compliance with the Constitution is now, ending the ambiguity that risks the rights of millions of Floridians.